Um, I'll be dealing with some case laws. Particularly, I'll be dealing with the NCLT and NCLAT decisions. And if time permitted, we can also move on to the High Court and Supreme Court cases. So, firstly, let me have a brief introduction as of the CIRP cases which have been handled so far. What is the overall status of that? So I'm just sharing a brief statistics. So I think my screen is visible. Just let me know if the screen is visible to everyone. Okay. So as we can see here, the data which is already published, it says that the total CIRP cases which have been admitted till December 31st, 2024. So this data is very much updated till last year, that is 31st December 2024. So till that date, how many CIRP cases were admitted? So this is the whole statistics regarding that. So total admitted cases were 8,175, out of which a few cases were closed. They were closed because of the reason of withdrawal under Section 12A. So around 1,130 cases were withdrawn under this particular section. Then there was a few cases which were closed on appeal or review, or they were settled. So around 1236, that is 1,236 cases, they were closed because of appeals or review or any kind of settlement. So this has happened that way. Then there were some cases, there were some CIRP cases where the plans were approved and ultimately the CIRP case was closed, and these amount to around 1,119 cases overall. And out of the CIRP cases admitted, a few were converted into the liquidation orders also, and on which already liquidation orders have been passed. So around 2,707 cases are such on which, though the CIRP was admitted, and ultimately it ended up with the liquidation order. Finally, the last data which we have is the ongoing CIRP cases in the country. They amount to 1,983. So still there are huge CIRP cases going on in the country. And as we all know, uh, there are many recent changes in the IBC. Also, there is a discussion paper which is floated on the website for uh, what our suggestions are for that, and it is asking for our suggestion. It is basically for streamlining the process of CIRP. So ultimately, as we can see over the period of this code commenced on on December 2016 and till date, this is the overall statistics of the CIRP cases which we have encountered with. So ultimately, if we see it through this bar chart, then in that we can clearly see that in the year 2017. So what we are checking out here is, I hope this is very much visible now. So this graph will easily tell you the year-on-year statistics which we have with regard to the CIRP cases admitted, cases which are closed, and the cases which are still ongoing. So if we see the data overall, in 2017, since it was just the beginning, there were only very few cases which were admitted or ongoing, and only one case was closed in 2017. And if we see the statistics overall, it has tremendously increased. And if we see it from the year 2022 till 2024, then the statistics clearly shows us that a lot of cases are being admitted year on year, and month by month we can say that a lot of cases are being admitted. And the ongoing ratio, it is Similarly, it is actually stagnating at this figure only, 1700 to 1900. So, as on date, also, we can find that all these cases are still pending and they are still going on. Because of variety of reasons, there could be because of the complexity of the case, because of any issues with respect to, NCLT or anything. So, there are constraints with respect to the time, but that is part and parcel of this code as we all understand it right now. So, what are we here to understand is we are here to understand, first of all, let us see one more diagram which shows that how the CIRPs are closed. So, out of the total submitted cases for CIRP, 44% have gone into the liquidation, and another 56% they have been settled or resolved or withdrawn. So this is the overall statistics which we can start our day with, that this is how the whole scenario is about the CIRP cases which we have. So moving further, we will discuss some latest judgments in various forums like NCLT and NCLAT. So I will be starting the session with NCLT decisions. Let me just share my screen again. My screen is visible. I'm just doing it full screen mode. Yeah, so we are discussing some case laws. So around 3, 4 cases of NCLT we will be discussing here, and these are the recent judgments. So let us start with the first question or the first agenda on which this decision is based. So the question here is, can we initiate proceedings against the personal guarantor under Section 95 even if there is no CIRP proceedings, or there are no CIRP proceedings which have been initiated against any corporate debtor or the principal borrower? Uh, so before I start, let me just give you a background how it goes. As we all understand that if there are any guarantees for any loan, so if a corporate debtor has taken any loan on the basis of any guarantee given by some director or any other person, so the contract of agency, it says that uh, you can file case on both the parties simultaneously. On the corporate debtor also you can file a suit, as well as on the guarantor also you can file a suit if the amount is not paid in time. So, as we also understand, the liability of the guarantor is coextensive with that of the principal debtor, which simply means that whatever amount is pending, whatever amount is due from the principal debtor or the principal borrower, or here in our case, it will be known as corporate debtor. So, whatever amount is pending on his part or on its part, the same amount equal to that same amount can be asked from the personal guarantor also. But the question here is, the question here is uh, whether we can straight away file Section 95 application on the personal guarantor rather than initiating any proceeding under this CIRP against the corporate debtor. The vice versa is very much obvious. I mean, if you first file a case on the corporate debtor under CIRP provisions, and then you file a case on the personal guarantor, it is okay. I mean, that kind of things we have seen also, and that is something which is happening. But we are today dealing with a case which is totally in contrast. That is something where we have not initiated any proceeding against the corporate debtor, but we right away want to initiate the proceeding under Section 95 against the personal guarantor. So before I go with the actual decision, I would like to hear it from you whether this kind of situation is possible. Any of you who would like to speak up? What is your take on this? We can have a mutual discussion. So that is why I am opening it up for the forum also. to have a general idea. What do you think, whether this kind of thing can happen or not? Any idea? I would request you all to please speak up. Let us have a brainstorming session instead of, just a monotonous session where I will be dealing with the cases and you will just be, digesting all of that stuff. So once you have a clear idea, I mean, when we discuss, the things become more easily understandable to each one of us, and we do not have to mug them up. So that is how it should be done. So if any one of you is interested, you can speak up your thoughts.
Yes, I think we can initiate CIRP proceedings against the personal guarantor. We can always start whether CIRP is on the way or not, because there may be applications pending or in the process of filing, but at the same time, personal guarantor is independent,
Right,
so we
sir.
can always file it.
Okay. So Praveen sir has given us one thought. Anyone who is contradicting to that? I'm just allowing you a few seconds more if any one of you has any different idea. And then we can probably see the case, how it goes, and what is the decision of NCLT on that.
You
So,
know, typically, if I may add to what
sure, sir.
is
Yes, sir.
typically a loan agreement is giving the freedom of the proceedings that we need to do. Yeah, that a bank can need to do in the event of a default. So that they can go against the borrower or the guarantor against any under any law, for example, IBC or SARP or anything. So it is up to the borrower in terms of, sorry, it is up to the lender in terms of which option he wants to choose in the event of default. So my sense is, if they choose to proceed against a personal guarantor, I think the loan agreements and not against the corporate debtor. I think the loan agreements typically give that freedom to the lenders.
Right, sir. Anisha has very well pointed out that loan agreements have this kind of option. So basically, what I can interpret from his thought is, because he's talking about the agreements and the contracts, the Contract Act clearly gives this freedom that you can file a suit directly on the principal borrower or the personal guarantor, any one of them or both of them. So in Contract Act, this is allowed. But what we are discussing here is, in the case of IBC, whether the same thing is happening in IBC or not, or it is parallel with the provisions as we have understood in the Contract Act, whether the same thing is happening or the same thing is applying in the uh, IBC also. So that is what we will be discussing in this particular case. I think the background is clear to most of you, and therefore we can proceed with the real or the actual case which has happened. So it is a case of UCO Bank versus Subrata Das, and this is a recent judgment which was decided on 17th December 2024. So let us discuss the facts of the case. This application has been filed by the financial creditor, namely UCO Bank, to initiate the insolvency proceedings against Mr. Subrata Das, the personal guarantor to the principal borrower, Messrs. Haridra Wintrade Private Limited, under Section 95(1) of IBC. So from the first para, we can point out that the financial creditor, that is UCO Bank, has directly filed an insolvency proceeding against Subrata Das, who is the personal guarantor to this principal borrower, Haridra Wintrade Private Limited. So he has directly filed the proceedings. So it had sanctioned a cash credit limit of 250 lakhs, and the amount of default by the corporate debtor as on 20th June 2024 is amounting to 303 lakhs plus future interest and charges as well. So for the whole amount, he is asking the personal guarantor to pay. The personal guarantor was duly served with the notice by the applicant requesting him for the payment, but no payment was made. So obviously he has followed the regular procedure, that is by serving the proper notice to the personal guarantor, asking for the funds, but no payment was made by the personal guarantor. Now CIRP process has not commenced against this particular principal debtor, that means the corporate debtor. On the corporate debtor, no CIRP process is commenced. That is what we are told here. CIRP process has not commenced as no application for initiation of the CIRP process is filed by the financial creditor against the corporate debtor. So in this case, we can very well make out that UCO Bank has directly initiated insolvency proceedings against Subrata Das, who is the personal guarantor, rather than filing a CIRP application on the corporate debtor. He has he has preferred to file this insolvency proceeding against Subrata Das directly. So what is the issue arising here? The issue is, so when this case went to the NCLT, they thought about this particular question, whether the proceedings against personal guarantor under section 95 of the code is maintainable when, even when no CIRP proceedings have been initiated against the corporate debtor or the principal borrower. Next question could be whether the present application under section 95(1) of the code against the personal guarantor would be maintainable before this forum. So this forum is NCLT, or should the creditor approach the learned debt recovery tribunal for its relief? So the question here arises is whether the personal guarantor on whom section 95 application has been filed on a particular NCLT, this application has been filed. Now the NCLT is checking out whether they have the proper jurisdiction of this particular application. So in there, so what they are thinking is, what the confusion is, whether the NCLT will have the jurisdiction in case if CIRP has not initiated at all, or the jurisdiction will be with the debt recovery tribunal for the relief. So I think the question is very much clear, whether the jurisdiction is with the NCLT. So again, first question was whether directly we can file an application on the guarantor, personal guarantor. So can we file directly on the personal guarantor? That was first question. Second question is, if you really want to file an application or you want to start the proceedings under IBC on the personal guarantor, what will be the jurisdiction? Whether it will be the NCLT or it will be the debt recovery tribunal. So I'm still stopping here, and I want the people who have just shared the views, and the other people also who are now, I think you have a fair idea what the question is all about and what could be the reply for that. Any idea now? Or you
Yeah,
are
so
still, yes, sir.
so in this case, it is immaterial that the application is filed or application is pending before NCLT for corporate insolvency resolution process, or even CIRP has been initiated. The jurisdiction of with respect to the personal guarantor would be the honorable NCLT, where the registered office of the corporate debtor is situated. And further, without even initiation of the CIRP process, application against the personal guarantor under section 94 or 95 both can be filed.
So according to you, the jurisdiction will be NCLT, right, sir?
Yes, sir. Yes, ma'am.
And the NCLT would be that which is located in the registered office place of that corporate debtor, right, sir?
Yes, yes.
Okay, okay. Can we have any other view also, if anyone is contradicting with that?
Uh, I think the
Yes, ma'am.
jurisdiction will be DRT because
Okay.
if there is no application pending with NCLT, the jurisdiction has to be DRT.
Okay. Any idea, ma'am, why you have opted for that debt recovery tribunal? Just because CIRP is not initiated, then we have to go for debt recovery
Yes,
tribunal.
because the rule is clearly stating that the case should be pending at NCLT. Only then the jurisdiction will be NCLT. Especially,
Okay, okay. So even the NCLT is of the same view of Jayashree ma'am. So let us see how it goes. So these are the observations. Section 128 of the Indian Contract Act 1872 stipulates that the liability of the surety or the guarantor is coextensive with the principal debtor, as we have discussed, unless it is otherwise provided by the contract. Now, as per section 179 of the code, essentially the adjudicating authority for individuals and individual debtor and partnership firms would be the jurisdictional DRT, that is Debt Recovery Tribunal. So this is clearly mentioned in section 179 that if you want to file some proceedings against any individual or any partnership firm, then you have to go through this Debt Recovery Tribunal. So what are the observations? We are discussing in detail what this section 179 is all about talking. So first subsection here says that subject to the provisions of section 60, the adjudicating authority in relation to insolvency matters of individuals and firms shall be the Debt Recovery Tribunal, having territorial jurisdiction over the place where the individual debtor actually and voluntarily resides or carries on business or personally works for gain and can entertain an application under this code regarding such person. So here it clearly mentioned that subject to the provisions of section 60, the adjudicating authority will be Debt Recovery Tribunal, and it will be in the same jurisdiction where the individual debtor is carrying on his business or the work. So it is here mentioned that it will be Debt Recovery Tribunal rather than NCLT. The second subsection here clearly says that the Debt Recovery Tribunal shall, notwithstanding anything contained in any other law for the time being in force, have jurisdiction to entertain or dispose of any suit or proceeding by or against the individual debtor, any claim made by or against the individual debtor, any question of priorities or any other question, whether of law or facts, arising out of or in relation to insolvency and bankruptcy of the individual debtor or firm under this code. So both section 179 of the code as well as section 94 and 95 use the word debtor and not personal guarantor. Under the regulations of 2019, a personal guarantor to a corporate debtor is a debtor himself. Under section 179 of the code, the said debtor has to approach the Debt Recovery Tribunal, and under section 94 and 95 of the code, the said debtor also has the right to approach the NCLT under the given circumstances as spelled out in section 60 and section 179 of the code. So if I stay here with this para, it clearly mentions that if CIRP is already initiated against that corporate debtor, then the jurisdiction will be of the NCLT. Otherwise, in the case where there is no CIRP has been initiated, in that case, if you want to still go for the personal guarantor, if you want to file any proceeding or you want to file any insolvency case against that person, application against that person, then in that case, clearly it is mentioned that Debt Recovery Tribunal will be the appropriate forum where you have to file the application. So again, there is one more case here mentioned, embassy property, which was in this case particularly the apex court mentioned that the jurisdiction of NCLT to consider an application under section 95 of the code against a personal guarantor to a corporate debtor starts when a CIRP is initiated against such corporate debtor. So we can refer to two important cases when we come to this particular question. The first case is embassy property and another case is Shapurji Palonji. So in both those cases, this thing was very well clearly mentioned that if any CIRP proceedings are already going on, in that case, the same NCLT will be taking up the proceedings against the personal guarantor as well. However, if no CIRP proceedings are going on against any corporate debtor and still you want to go ahead with the personal guarantor, then in that case, the application against the personal guarantor will be made to the debt recovery tribunal only. So that is, I think, a very, very important point, or the very important takeaway. We have to clearly identify the jurisdiction here. If you want to initiate an application against personal guarantor, then firstly, where this application will go to. So what is the jurisdiction? So in that case, you can bifurcate it into two parts: if CIRP is initiated or if CIRP is not initiated. In case where CIRP is already initiated, the jurisdiction lies with the NCLT. And if there is no CIRP proceeding going on, in that case, debt recovery tribunal will be the appropriate jurisdiction. Am I clear till here?
Ma'am, I have a question here.
Yeah, ma'am.
Suppose the case was initiated and now it is resolved. All the all the proceeds have been distributed. So now after that, if the application is to be filed against the personal guarantor, then the jurisdiction should be NCLT or DRT.
So you are saying that CIRP has already, under CIRP, all the things have already settled.
Yes.
And still we want to go for the remaining amount.
Yes.
But ma'am, let me just understand. If a CIRP is already taken place, then we already identify how much will be the liability of that particular financial creditor, right? And the whole
Liability
amount is
of
yeah,
the corporate debtor.
of the corporate debtor, right? So suppose the liability was of, suppose 1 CR, we can assume the liability was of 1 CR, and the whole amount is paid. Maybe some haircut was there and he has been paid full, right?
They
Whatever amount was
got a
there,
resolution plan for 1 CR, but that is not enough
that is not enough, right?
to pay off the liabilities, and that
Yes,
is why they want to go against the personal guarantor.
right, ma'am, right.
So now what should be the jurisdiction?
Ma'am, if the CIRP is already over, the resolution plan has been successfully implemented also. In that case, since there is no CIRP going on, then we can clearly say that the jurisdiction now will be debt recovery tribunal.
Yeah.
But,
Okay.
but if CIRP is going on, and meanwhile you can, if you want to initiate any proceeding on the personal guarantor, in that case, IBC presumes that there should not be two courts handling the same issue. It should be with the same forum. So that is why they are saying that NCLT would be the appropriate forum if CIRP is going on anywhere. And if CIRP is not going on, then in case of individuals, you should go for DRT, that is Debt Recovery Tribunal.
Okay. Thank you, ma'am.
Okay. So let us understand what was the final decision here. In terms of section 61, 60 subsection 1 and 2, read with section 179 of the IBC, NCLT is the only adjudicating authority in respect of personal guarantors to a corporate debtor where this is the underlying condition, where a corporate insolvency resolution process or liquidation proceeding is initiated against a corporate debtor, and it is either pending before NCLT or is already concluded. So here I think the message is very much clear. So if the things are already covered, then this is the thing which this is how it should go. In the absence of an initiated or pending or concluded CIRP against a principal borrower, an application under section 95(1) to initiate insolvency resolution process against a PG to a CD will not be maintainable before the NCLT. So I think, ma'am, your doubt is very much clear here. If proceedings are already over, so even concluded word is added here. So it is saying even if it is concluded, since the case was going on in one NCLT, I think the better option would be to go to that particular NCLT only rather than going to this DRT.
Okay, ma'am. Okay.
So this is what their view is, but I mean, this can be challenged further because this is only the view of NCLT. So DRT can be also taken into jurisdiction. But again, what I feel here is just to avoid any kind of confusion, since NCLT is already aware about the whole idea, the same matter should go to them. This is how they have interpreted in this particular case. So all the three words are important.
Yes.
Initiated, pending or concluded. So if anything is happening that way, so the court would be the adjudicating authority would be NCLT, right?
Okay, thank you, ma'am.
Okay. The recovery proceedings will lie only before the debt recovery tribunal having territorial jurisdiction. So if this kind of conclusion would not have been there, we would be assuming, just like ma'am asked earlier, that what will happen to the cases if anything has concluded in CIRP, what will happen to the application against the personal guarantor. So here they have finally concluded it in such a manner that all the three words are important: initiated, pending, or concluded. In all these cases, finally, the proceedings against the personal guarantor will be only in the NCLT. So, in this particular case, the application was dismissed. Now, moving further to the next, I think there are some questions in the chat box. So what is it? Okay. Let us move further to the next case. Thus, pendency of proceedings before Maharashtra REAT and Maharashtra RERA bar the initiation of CIRP under the code. So, just let us understand here that we are discussing the section 238 probably, which says that IBC will override all other acts and other authorities. So it is just asking you a question here. The case which we will be discussing is basically related to the scenario where some case is going on or some proceedings are going on in a particular jurisdiction, in a particular public forum for this Maharashtra RERA Act or something. Will that bar the initiation of CIRP under the code? So what is your take on that? And then we can proceed with the case law which we have. Anyone? Whether both the things can go simultaneously, or as we know, if we start the CIRP process, the other things will be in the moratorium or things like that. And the third scenario which it is asking is, if any case or proceeding is going on in this particular act, Maharashtra RERA Act or something, then in that case, whether CIRP is allowed or not. Whether
I think CIRP is allowed because these are the specific act for the real estate.
right, sir.
If they cannot resolve the thing, you can go to CIRP, and CIRP is a separate process. This is in RERA also. I think now they are coming with a proposal to change the management like in CIRP.
Hmm.
So if that thing comes, then there may be a change. But at present, I think CIRP can be initiated in the cases.
Okay, sir. So according to you, at both the forums, parallelly, we can initiate the proceedings, or we can carry on with the proceedings.
No, once CIRP is issued, then moratorium will start.
Then moratorium will start. Okay. So for the time being, we can initiate the process of CIRP. That is what your take is. Any
Yeah.
other view? Any other view before we go ahead? See, once we discuss, the concept becomes very much clear, and we will actually learn out of what we are studying. So your time which you are investing will be actually utilized. Anyone else on this? Can we go ahead? Okay, then let me move further. So the actual case which has happened here is Rajendra Raja Bali Singh versus Rohan Developers Private Limited. And again, this is a very recent judgment. It was pronounced on 6th February 2025 itself. So what are the facts of the case? Let us understand. The case involves home buyers of a real estate project, 7 U's, developed by Rohan Developers Private Limited, which is the corporate debtor in our case. The petitioners, that is the home buyers, filed an application under Section 7 of the IBC 2016, claiming a financial debt of 82.23 crores, with the date of default being 30th December 2023. The corporate debtor had entered into agreements with the petitioner but failed to deliver their apartments despite receiving substantial payments. The project was registered under RERA and its completion date was revised from 31st March 2020 to 30th December 2023, but no substantial construction progress was made. The petition was filed as the home buyers collectively held 7 units exceeding 10% threshold required to file the case under IBC. So in this particular slide, we can make out that the home buyers had filed an application under section 7 of the IBC and claiming that this is a financial debt and this much amount is pending. The developer is not doing any kind of construction and we want our money back, or maybe the property, whatever the thing is. So this is the total amount which they are claiming. This is the financial debt which they want. And again, it has been proved that they collectively hold more than 10%, then therefore they can easily file a suit or they can easily file this application under IBC. So what is the issue arising here? The first issue which is arising here is delay in the project completion and default in the financial debt. The corporate debtor received substantial payments but failed to deliver the flats. Corporate debtor claimed that RERA completion deadline was extended, but the petitioners argued that default had already occurred. What are the various provisions which were contravened? So section 5.8 of IBC, that was the first and foremost which was contravened, which defines a financial debt and it includes the home buyer's payments as well. Then section 7 of IBC, which allows financial creditors, that is home buyers, to initiate CIRP if any default occurs. Then section 14 of IBC, which is moratorium, and it says that it prevents further legal proceedings against the corporate debtor once CIRP is initiated. As Praveen sir just now mentioned that once CIRP is initiated, all the other proceedings will stand still, maybe in RERA or wherever it is pending. The next issue here is corporate debtors' objection on eligibility of the petitioners. So since obviously they are filing a petition, the corporate debtor would, try to object that. So they will try to counter that. So they are saying that the petitioners are not eligible at all. The corporate debtor argued that 2 petitioners were only assignees and not the original allottees, and hence they did not qualify as the financial creditors. So what is the difference between assignees and original allottees? Allottees are the persons to whom actual allotment was made, and those persons have again assigned it to someone else, and the other persons, the assignees, basically they have initiated this section 7 petition application. Yes. The corporate debtor also claimed that some petitioner claims were pending before RERA and Maharashtra RET, making the CIRP petition non-maintainable. So corporate debtor is of the view that since already proceedings are going on in some other forums, then it is not, it should not be maintainable in the IBC scenario. So again, the third issue which we can come up, which we can see here is project-specific insolvency versus insolvency. Can others please mute their mic?
लोकेशन नहीं है
Sonu ma'am, can you please mute yourself?
देखिए डिंडोरी का लोकेशन मैं भेजती हूँ तेरे को, पहले तो उसको फिर दे वो जो उसने भेजा है फैक्ट्री वाले ने.
Sonu ma'am, please mute yourself. Thank you. The tribunal noted that an error in its initial order where insolvency was initiated against the entire corporate debtor instead of just 7 use project. So normally we understand that a developer takes up a variety of projects, and this was brought to the notice of tribunal that some error has happened. Some error has happened while giving out the order or mentioning it in their proceedings, that instead of a particular project, they have mentioned some other project. So that thing has been rectified. That was the issue, or that was one more issue which was mentioned here. Corporate debtor argued that it was executing 3 other projects and insolvency proceedings should not affect its other developments. So again, corporate debtor was saying that since variety of projects are going on, the insolvency proceedings of one project should not hamper the other projects. And that is something which we all understand. So RERA versus IBC conflict, what is it? IBC, will it override RERA in case of conflict? And this was actually upheld in Pioneer Urban Land and Infrastructure Land versus Union of India. So basically, there is a clear-cut case which says that IBC will override RERA in case of any conflict. And this was clearly mentioned in this particular case law, which is Pioneer Urban Land and Infrastructure Limited versus Union of India. The fourth issue which could arise here is related to the contentions of the loan liabilities and pending litigations. The corporate debtor argued that its joint development agreement with Indo Global Soft Solution was terminated and that Indo Global's pending CIRP should be considered. Loan liabilities of Indo Global to ICICI Bank were transferred to the corporate debtor, complicating the financial structure overall. So again, this corporator is saying that there is some kind of joint development agreement with some other corporate debtor also. The name is mentioned here, that is Global Soft Solution. And again, that Global Soft Solution also some CIRP proceeding is going on. So that is why the whole situation has become complicated. Loan liabilities of Indo Global to ICICI Bank were transferred to this particular corporate debtor, complicating the whole of the financial structure. So again, if we take a look at section 66 and 67 of IBC, which is related to fraudulent transactions, the corporate debtors restructuring of loans raised concern about the financial mismanagement. The NCLAT order in ICICI Bank case 2023, it mentioned that the tribunal had already acknowledged the settlement between Indo Global and ICICI Bank. So what is the final observation? The tribunal dismissed the CD's objections, holding that first, home buyers qualify as financial creditors, even if if they are assignees. So the first and foremost, the counter thing which was made by this corporate debtor, or the objection which was made by the CD, was that they cannot maintain this application just because of the fact that these persons who are calling themselves as home buyers, they are not considered as financial creditors since they are assignees. So it is very well made clear here that even assignees fall into the definition of financial creditors. The first thing is that, therefore, if any application is made by them under IBC, then that will be taken care. Moving further, pendency of proceedings before RERA or Maha-RET does not affect IBC proceedings. So simultaneously, both the things can go. So it will not affect. Default occurred before the extended RERA deadline and IBC considers default at the time of application. So at the time of filing application in IBC, ultimately, they will see what is the date of default. So the extended deadline, that was 30th December 2023, I guess, that will be taken as the date of default in case of IBC. Again, the project-wise insolvency was valid and insolvency proceedings were limited to this particular project of 7 years and not entire corporate debtor. So again, if you are filing insolvency proceedings or the CIRP proceedings against a particular developer, in that case, only one of the projects will be targeted and not all the projects of that particular developer. So it is not against the entire corporate debtor as such, it is only against one of the projects where these home buyers are actually connected with. So what is the final order? The tribunal admitted the CIRP petition under section 7 of the IBC. Moratorium was imposed, as we all know, and the IRP was appointed, and so that was the only thing. So ultimately, the question which was asked in that particular case was related to whether the assignees will be considered as the financial creditors, whether they can initiate the proceedings of CIRP. First thing was that. Second thing is, if any RERA proceedings are going on, then still can we file CIRP application? Yes, you can clearly file CIRP application, but once it is admitted, then moratorium will be established and other proceedings will become standstill. Now, moving further, this is the third question, or this is the third agenda on which we will have our next case law. So the question here is, or the agenda here is, whether prior proceedings under the SARFAESI Act qualify for the exclusion of time under Section 14 of the Limitation Act 1963. So if we all know that there is a Limitation Act which limits that if the limit is already over, you cannot initiate the CIRP proceeding or any other proceeding. So if a case is going on in SARFAESI and again, because of the time-taking activity there, whether that particular time of proceeding can be excluded from saying that the default might have occurred in suppose 2005 and still the case is going on, and now you want to file a case for that particular corporate debtor, saying that giving the excuse that it is still going on in SARFAESI and we need to exclude the time since the prior proceedings are going on in some other act. So the question here is whether the Limitation Act is applicable, the provisions of Limitation Act with respect to exclusion of time, whether it is available in case any prior proceedings are going on under the SARFAESI Act. So any idea, any clue how will it be taken up?
No, it will not be excluded.
It will not be excluded. Okay. Any specific reason, sir?
No, means practically we are doing it as such. It is not happening, means not allowing, means as such.
Okay. Okay, that is your view. Any other view? Those who say that it will be allowed? Okay, let us see what this case talks about. So this is a case, a real case in the case of Omkara Assets Reconstruction Private Limited versus Vidarbha Sugar Mills Private Limited. And again, this is a recent NCLT judgment which was pronounced on 7th February 2025. So what are the facts of the case? Omkara Assets Reconstruction Private Limited, which is the financial creditor in this particular case, filed an application under Section 7 of the IBC 2016 against Vidarbha Sugar Mills Private Limited, which is the corporate debtor here, on 24th October 2019. So Vidarbha is the corporate debtor and Omkara Assets Reconstruction is the financial creditor. And an application under Section 7 was filed on 24th October 2019. Corporate debtor had availed a working capital loan of 1.5 CR, which was later converted into working capital term loan on 29th March 2014. Due to the continuous financial losses, the corporate debtor defaulted on payments, leading to an outstanding debt of 3.66 crores as of 1st May 2015. The account was declared as non-performing asset on 30th June 2015, and recovery proceedings under the SARFAESI Act 2002 were initiated. Omkara Assets Reconstruction Private Limited acquired the debt on 21st March 2022 and sought CIRP initiation. So whenever there is a question of limitation, we have to pay more attention to the dates. So again, here it is mentioned that some SARFAESI proceedings were going on and the recovery proceedings were finally going on in this SARFAESI Act 2002. They were initiated on this 30th June 2015, and finally they acquired the debt on 21st March 2022. And then at that point of time, this Omkara Asset Reconstruction Private Limited, which is the financial creditor, it sought for CIRP initiation. Now the question here is whether the present application filed under section 7 of the code on 24th October 2019 is barred by limitation or not. So let me go back to tell you the dates. So in the first para itself, it is mentioned that the application was filed on 24th October 2019. However, at that point of time, SARFAESI proceedings were going on. And ultimately, if we see the last line, Omkara Assets Reconstruction Private Limited, they acquired the debt on 21st March 2022, finally. So the issue here arises is whether the default in repayment, where there is a default in the repayment of financial debt. I think that is very much clear. We can proceed with the next issue. The second issue is with relation to the delay and limitation period of CIRP initiation. The corporate debtor argued that the CIRP application was time barred as the default occurred on 1st May 2015, but the CIRP application was filed in 2019. The financial creditor countered that limitation was extended due to ongoing legal proceedings under SARFAESI Act. So what are the relevant provisions which can be taken care or which can be read here to have a better understanding? First is section 238A of IBC and section 14 of the Limitation Act 1963, which excludes time spent in other legal proceedings from the limitation period. There is again one more judgment with respect to this. Judgment in the case of Sheshnath Singh versus Vaidyavati Shirora Fully Cooperative Bank Limited. It confirms that SARFAESI proceedings extend the limitation for CIRP filing. So, sir, what you were saying, you have a case law exactly for that, and a section was also mentioned for that. You can take note of these, and it clearly says that SARFAESI proceedings, if any are going on, they will extend the limitation period. This is what here they are saying. Let us read it further. The third issue which could arise here is with relation to the corporate debtors non-cooperation. The corporate debtor did not file a reply in multiple hearings despite of being granted time. And I think this can be taken care, it's okay. The main point which we want to discuss will be given in this particular slide. So what is the observation of NCLT in this particular case? The limitation period in respect of the debt owed by the corporate debtor will get extended. Again, I am reading this word with a great emphasis. It will get extended from time to time due to exclusion of the time spent in ongoing proceedings under the SARFAESI Act and subsequent proceedings initiated by the corporate debtor before Honorable Bombay High Court and Honorable Supreme Court. The financial creditor benefits from the exclusion of the time spent in recovery proceedings under SARFAESI Act in terms of Section 14 of the Limitation Act. Therefore, we hold that, so it is in the words of NCLT, we hold that the present application filed by the financial creditor under Section 7 of the code is maintainable. So even if the corporate debtor is saying that it has lapsed the time or it is now time barred, NCLT is of the view that this application can be very well taken into account because of the fact that the proceedings under SARFAESI or any other proceeding, they are just extending the limitation period. So this is the thing which we all can take note of and we can very well use in our cases also. So these are the further observations. With regard to the default and repayment, the corporate debtor availed financial assistance. I think this is okay. We can directly move on to the final order. The CIRP petition under Section 7 of the IBC was admitted. Moratorium was established and all that thing. So ultimately, the final decision which we can draw from this particular case is that the limitation period gets extended if any SARFAESI proceeding is going on. So I think you are digesting all these three cases, all the three simple fundas which we have understood. First was with relation to the personal guarantor. Then we came across the RERA proceedings. If they are going on, can we file the CIRP proceeding simultaneously? Yes, we can. And the third one was related to this case, that whether the limitation period will get extended. Yes, the limitation period will get extended in case any SARFAESI proceedings are going on. Can I move further with the NCLAT decisions? Are we all together? Or we need a break? How is it?
No, it's going fine. Continue,
It's going
please.
fine. We have just studied three cases, sir. So I think we can
it
move
was
further.
wonderful.
Okay, we
It
can.
enhances the knowledge.
Yeah, at least we will be learning, sir. It is just not
Yeah.
one-sided, monotonous, deliberation from my side.
That's great.
So at least whatever you are learning it by heart. Maybe not the case law name, but still the concept will be clear with you.
Yeah.
Okay, so I'll be just.
My
Yes,
one
sir.
question.
Yes, sir.
In case SARFAESI proceedings are on,
Yes, sir.
and ultimately banks go for one-time settlement, and then operational creditors, if they file the CIRP application, what will be the status?
So
Because bank
if
is out, financial creditor is out, but there may
So
be
let
other
us
financial
let us
creditors.
just understand it one by one. So CIRP application is already filed, right?
Yeah.
And meanwhile, OTS is proposed by someone.
Yeah. The OTS is done.
Okay.
Bank is out. He files 12A.
Okay.
for
Yeah, of
withdrawal.
course, sir. Of course, there is no point continuing the CIRP proceedings. They
Yeah.
can very well withdraw the application. So that is very settled law. Yeah.
But there may be other financial creditors or unsecured financial creditors who want to continue the proceedings. Then what will happen?
Sir, again,
What do you see?
if you know that for withdrawal also some voting is done. So if
No,
you have a
but
certain
see,
percentage.
we are handling a case where when CIRP was admitted, immediately within 15 days there was a stay order
OTS.
from NCLAT.
Acha,
And
okay.
after 3 years now we are going for an OTS. We hope to do the OTS in place, but at the same time there are other creditors who have not filed the claim. Now they are approaching to the court and saying that yes, we want to continue this CIRP. Why CIRP is withdrawn and like this application moved. So these are the matters pending
So
before the
within time,
NCLT.
if people have not submitted the claim, that is one issue. So whether their claim will be entertained or not. So that is one issue which I can make out here is. And another issue, what you are saying is you want to go for this OTS, but the others are not allowing you to go for that.
Yeah.
Sir, in my view, again, if you want to withdraw because of this OTS, that section particularly makes out clear cut. There is a provision how much percentage of votes are required to finally withdraw. So if
No, but
majority is there,
there is no COC.
there
As
is
on
no
date, there
COC
is
at
no
all.
COC. Yeah. So applicant and financial this CD both can sign an agreement and they can withdraw.
Of course, they can withdraw. Then,
But
if anyone
everybody is,
else,
they are entering in the NCLT, and they are saying that if you are settling with the financial creditor, you settle overdues also. So there are 100 crores of rupees outstanding for operational creditors.
let them file another application in that case.
Yeah, that NCLT is in the process of deciding what to do, but they say that you have to hear everybody. It's a problem.
What is the view of others? I mean, as per my view, I think because there is no COC at all, and how the decisions will be taken care. Ultimately, you have to go as per the saying of tribunal, NCLT only. So you can, on a safer side, being a resolution professional, be on a safer side. What you can do is you can report this kind of matter to NCLT and have their view on that. So whether they will allow this withdrawal or whether I mean, they want the others to be considered or howsoever it should be. But if, yeah.
No,
May I come in,
NCLT has asked one question to all the creditors, whether you want to continue CIRP, meaning if promoter is going to settle everybody, then why you want CIRP? Settle it with the promoter, because the OC will
That is
not
the
get anything.
best recourse. That is the best
Yeah.
recourse, obviously.
Because OC will not get anything out of CIRP. It's better to settle with the promoter. So this is
But
what
they are not
has
letting
come
you
up.
settle. That is the only thing.
Yeah, it's under negotiation. We are
That
doing
will
that thing.
that is the hard reality, sir. We have to face
Yeah,
that. Yeah.
yeah,
Even
that is.
NCLT is not able to answer. How can we, sir?
Yeah, thank you.
Okay. Okay. Uh, can we move further with the NCLAT cases? Let me just share the screen just a second. Is it visible? Is the screen visible or not yet? So here we are with the some more decisions by NCLAT. So another questions for all of us. So I'm actually asking you a lot of questions, but that is how these things will be memorized. So, okay, so this is another agenda which we need to understand. The question here is whether late claims beyond 90-day period are entertained. So I think in your case also, since they were in your case also, you were mentioning that a few people did not give their claims or they did not uh, uh, gave their claims on time. So whether they will be allowed now, I think your question will be answered here. It might be answered here, sir. So whether late claims beyond 90-day period are entertained. First question is this. Second question, which we will be understanding here, is whether resolution plans, once approved, can be reopened for new claims. Next question is, are government tax dues, which are not automatically treated as secured debt under IBC? So, should I read this third part again? Are government tax dues not automatically treated as secure debt? Or I can put it in a different way, saying that whether the government tax dues, whether in the case of government authorities, whether they are supposed to file claim or their dues are taken directly as it is, they are taken as claim. So this is the third question. Fourth question is whether IBC overrides tax claims, ensuring resolution applicants are not burdened with new liabilities. So let us go one by one. What is the answer for the first question? Let me hear from all of you whether late claims beyond 90-day period are entertained. Whether late claims are entertained. Any one of you can answer, please. So there is a time limit within which the creditors have
Only
to.
if
Yes.
NCLT approves that admission.
So,
Otherwise, no.
I mean, being a resolution professional, how should we take it up? We should not entertain it. We should directly ask the NCLT to give us the permission to include. That is what you are saying, sir?
No, the claimant should go to NCLT, and if NCLT approves, then that order can be used as a basis for admission of the claim or at
Okay,
least
so
verification of the claim.
Okay, so for the resolution professional, he is not bound to accept any claims beyond the time limit. That is the set rule, right?
Yes, yes.
Okay, 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 Anish sir. So let us go for the second question. Let us hear it from you whether resolution plans, once approved, can be reopened for new claims. So if resolution plan has already been approved once, can it be reopened for new claims? So claims here simply means if anyone has not given his or her claim earlier and now they are saying that even our amount is due, though already the resolution plan is approved, but can they come up saying that even our dues are still to be entertained? What will be your take on that? Being a resolution professional, how will you take up this second question? Anyone, please, because this is a very simple one, I think. If the resolution plan it is already approved, can it be opened for
No,
new?
I don't think it can be opened again. Only if you go to Supreme Court, then only is possibility. Otherwise, once implemented, once approved, it's approved.
Okay, so
Because
Madam, can you
otherwise
please,
everything will go in
I will
vain.
Madam, I'll request you, can you please, for the 90-day period of late claims, you were not audible in little part. Can you please complete that?
ma'am,
Whether
we
we
were just
can file?
asking the question. We were just asking the question. We have not concluded anything yet.
Okay, okay, yes, ma'am.
Yeah,
Okay, okay.
we are
Because
just
even I want to know the answer.
brainstorming.
Okay, okay, okay.
Of
Thank you.
course, ma'am, of course. The case will be discussed in a short while, but before going directly to the case, we must first analyze what are the questions, what are the complications. Yeah,
Anji.
okay. So anyone else on the second question, whether resolution plans once approved can be reopened for new claims?
No, ma'am, it cannot be.
Okay, okay, fine, Jayashree ma'am. Okay, we can proceed with the third question now. Are government tax dues which are not automatically taken, or I think the language here is not very much clear. I'm rephrasing it in my words. It should be taken up like this. Suppose income tax authority has some dues and it has not filed any claim. It is presuming that its claim will be settled automatically because they are the government authorities or something like that. So is it that they are bound to provide their claims? They have to submit their claims. Is that mandatory, or the government dues are taken as it is without even filing any claims?
So they have to file
They have
claims
to file the
because
claims.
They have to file the claims. Okay, okay. And the last question, whether IBC overrides tax claims, ensuring resolution applicants are not burdened with the new liabilities. This resolution applicant, which we are saying the successful resolution applicant maybe. So
it
if
is within the parameter, whatever claims have come accordingly, will file the resolution plan.
exactly,
So
exactly.
it is nothing that tax authorities or other can come and ask for anything and everything to the successful resolution applicant.
Right. So question number 2 and 4 are kind of interconnected questions if you can
Yeah,
see. Yes. So if already a resolution plan is approved, and then income tax authorities or any other government authorities are coming up and saying that we did not submit a claim, assuming that we will be given or we will be taken care of automatically, whether they will be entertained or not. So that is the crux which we will be understanding in this particular case. So I think we are good enough to move with the case, which is the actual case here is Commissioner of Income Tax, TDS1, Mumbai versus Sundaresh Bhatt and others. This is again a recent judgment which was pronounced only on 15th October 2024. So let us understand the facts of the case. Commissioner of Income Tax, TDS1. So basically, it is the matter of TDS. So Mumbai appellant here they are considered as appellant because they have filed an appeal in this NCLAT. They have filed an appeal under Section 61 of the IBC 2016 against the order dated 13 March 2023 passed by NCLT Ahmedabad bench, which approved the resolution plan for JBF Petrochemical Limited, which is the corporate debtor. So what we can see here is the resolution plan is already approved for this particular corporate debtor, and this commissioner of income tax, Mumbai, they are now filing an appeal against this particular resolution plan or the order of the NCLT. They are just saying that the order was not appropriate. They have filed an appeal. Corporate debtor was admitted into CIRP. Now we are going in a flashback. So how it happened and all. So corporate debtor was admitted into CIRP on 28th January 2022 following an application under Section 7 of the IBC by IDBI Bank. So IDBI Bank is the financial creditor, and it had filed application under Section 7 for the CIRP. Then resolution professional invites claim from the creditors, and the 90-day period for filing claims ended on 28th April 2022. So mind the dates, please. So 3 months period, that is 90 days, is already over on 28th April 2022. Now, the Income Tax Department, which is the appellant in our case, filed its claim for 10.14 CR on 13th May 2022. That is well after the deadline of filing the claims had expired. So they have, this very much makes it clear that they have filed their claim beyond the time limit which was given for the claimants. The resolution professional thereby rejected the claim, and the COC approved the resolution plan without considering the income tax claim. The NCLT approved the resolution plan on 13th March 2023, prompting the Income Tax Department to appeal before the NCLAT. So NCLT is clearly saying that in their order, maybe they are not paying any attention to the Income Tax Department's claims because they had not filed in time. And again, they are not holding RP liable anyhow. So RP has done his job. He has come up with the resolution plan, and he has got that approved also with the COC, and got that approved again in the NCLT. So finally, NCLT has given the order that this resolution plan is approved from their side. And if this Income Tax Department has to get its claim, it has to file an appeal to the NCLAT. So that is what they have already done. So in this particular case, what will happen? Let us see. The appellant, that is the Income Tax Department, submitted its claim of rupees 10.14 crores after the last date of submission of claim, but before the resolution plan was approved. So again, we are given the fact that they had given their claim, already they had submitted their claim, but till that time, obviously, the resolution plan was not approved. So again, it has mentioned that the resolution plan could have still taken their dues. That is what their idea is. The Income Tax Department is of the view that since your plan was not approved, you could have still, incorporated our claims, but you did not do so. So that is what it is saying, even though they had filed it after the time limit. So it claimed that it was not informed of its rejection by the resolution professional. Now, the Income Tax Department is saying that they thought since they have already submitted the claim, maybe after the time limit, but since the resolution plan was not accepted, they thought that their claim will be taken care. However, it was not accepted by the resolution professional, and the Income Tax Department is of the view that resolution professional should have informed or should have communicated it to the Income Tax Department that their claim has not been entertained. So the rejection thing should have been reported to them by the resolution professional. This is what they mean here. On an application filed before adjudicating authority by Income Tax Department against the rejection of their claim, the said application was dismissed. So finally, when this application was filed before the adjudicating authority, that is the NCLT, their claim was rejected, and therefore they were bound to file an appeal with the NCLAT. So what is the issue arising? I think we all understood till this point of time that whether the income tax department showed due diligence in submitting the claim, whether they had submitted their claim in time, even if it is so, there could be some view that if you are submitting the claim before the acceptance of the this resolution plan, it will still be taken care. So there any provision in the code which says that delays can be entertained? If there is anything, then obviously this will be taken care, but let us see how it goes. So another issue which we can say that what might have come up here is the delay in filing claim, which we all understand. The appellant did not submit the claim within the 90 period of time. So I have just written it again so that to make the things easily understandable. The RP rejected the late claim and the COC processed the resolution plan without including the tax dues. I think this is very much clear. Then the income tax department is putting an allegation of natural justice violation. What kind of natural justice violation is there? Because the appellant claimed that resolution professional did not communicate the rejection of its claim. Otherwise, they would have, asked the COC to consider, and then the resolution plan should also have been framed that way. So that is what they are saying, that natural justice violation was also done in this case. The RP countered that multiple public announcements were made. Now, as a resolution professional, how you can take this up? So in this particular case, what he has done is he has given his facts, he has given his point of view that he has already communicated it multiple times through public announcements and updated the creditors list, which was regularly uploaded on the corporate debtors website and IBBI portal as well. So income tax department should have seen from there why you did not see it from those public portals which are already open. So it is not my duty to communicate. That is what here the resolution professional is trying to convey. The appellant failed to challenge the rejection before the RP or NCLT despite multiple hearings. So again, finally, what we can say is, can the claims be admitted after approval of the resolution plan? So finally, this is the issue which we must understand, whether the income tax department's claim should be included even after the resolution plan is approved. So there's a particular case also here we can see, Ghanshyam Mishra judgment in 2021. It was highlighted in that particular case that no new claims can be entertained after resolution plan is approved. And similarly, in one more case, that is Committee of Creditors of SR Steel Limited versus Satish Kumar Gupta, a successful resolution applicant must start with a clean slate and new claims cannot be imposed later. So this Satish Kumar Gupta case is from the point of view of the resolution applicant. From his point, it should be clearly mentioned that there will be no new claims going further. So he should start with a clean slate. Whatever is done is done. He will not entertain any more or any new claims, even though they were not given any consideration in the resolution plan. So once a resolution plan is approved, it becomes binding on all the stakeholders, including the government also. So this is clearly mentioned in section 31, subsection 1 of the code. So this is how we must take it further. So what is the final observation? Regarding the RP's conduct, whether he was acting in a diligent way? Yes, the RP acted transparently by publishing notices and updating the creditors list. The income tax department failed to exercise due diligence in submitting their claims on time. Regarding the admission of late claims, obviously we understand that IBC is a time-bound process, and admitting late claims defeats the very purpose of the insolvency resolution. And this case, which we have already discussed, on finality of the resolution plan. So whether that resolution plan will be considered full and final in that scenario? Yes. The COC approved the resolution plan, and now it is binding on all the stakeholders, whether or not the claim was, entertained or not. Allowing post-approval claims jeopardize the resolutions and contradicts the clean slate principle. So again, these are the final observations which we can discuss. The RP was empowered to seek additional evidence to analyze the admissibility of the claim. So, okay, this is one thing which we can think upon and we can discuss. The resolution professional is given power to ask or to seek additional evidence as to if he wants to admit any claim. So he can ask the reasons why this has been delayed, and if he thinks that that is sufficient cause, there was a sufficient cause to it, then obviously he can admit that particular claim. Otherwise, as previous discussion was also happening, that it should be brought to the notice of NCLT, and if they agree, then only this claim shall be entertained or admitted. CIRP regulation does not provide any discretion to resolution professional for admitting the claim after the extended period. So if the period has been already extended, now you should not accept the claims. This is the clear cut guideline for the resolution professional. I mean, the resolution professional has to work within the CIRP regulation, and he does not have any discretion to admit the claims after the time period. Putting the status of claims on the of the creditors on the website of the corporate debtor and the IBBI portal amounted to deemed knowledge and constructive notice on the income tax department in respect of the rejection of its claim. So this third point is a very important thing from the point of view of resolution professional, how he can prove that he has done his part of job. So if you are doing if you are putting the claims on the websites of the corporate debtor and the IBBI portal from time to time, you need not to give personal notices to individuals or to any other creditor. It is just that it is not your duty to personally inform each and every. So that is what is observed by the NCLT. They have clearly mentioned that. The provisions of the Income Tax Act do not create any charge or security interest on the corporate debtor. So, since there was a preconceived notion with the Income Tax Department that this claim will be entertained, so here it is clearly observed by the NCLT that as per the Income Tax Act also, there is no provision which says that the amount due will be treated as a security interest or it will create any kind of charge. So if they are not submitting within time, their claim will not be entertained. After approval of a resolution plan by both the COC and adjudicating authority, no surprise claims should be flung on the successful resolution applicant. So ultimately, it is for the purpose of successful resolution applicant. It is for his positive thing. There, whatever is decided in the resolution plan, nothing more than that he is supposed to pay. So that is the ultimate observation of the NCLT in this particular case. So what is the final judgment? The appeal by the Income Tax Department was finally dismissed. The approved resolution plan remains binding and the tax claim cannot be entertained. The resolution plan is to be implemented as approved by the NCLT, and finally there were no costs awarded in this particular case. I think this case is easy to understand and now you can very well connect with it. Moving further to the next questions. I'm just checking if there is any question in the chat box. Okay. Okay. So time for another question. Time for another points of discussion. So the next point of discussion is whether government dues must be treated under IBC's resolution process or they can be recovered independently. It is regarding government dues. Second question, whether IBC overrides sectoral laws. So what are these sectoral laws? Whether IBC is overriding that, we will see that in our coming case. Then third question is whether RPs can be held personally liable beyond their statutory rule. That is a tricky question. Then next is whether preferential treatment of government claims is against the IBC framework. So let us go one by one. What is the answer for the first one? Whether government dues must be treated under IBC's resolution process or they can be recovered independently.
It's an umbrella process, so everybody has to come to IBC. Then
Yeah,
only
it
it
has.
can be resolved.
Right, sir, right. And it was very well discussed in the previous case also.
Yeah.
So the first question can be easily answered. The second question, whether IBC overrides the sectoral laws.
No, I don't think, because like NGT, environment law and all, you cannot say that NCLT has approved and you can start a polluting unit. So these are
Right,
the
sir.
specific sectoral laws which have to be complied with.
Right, sir. Very well mentioned. And this will be particularly discussed in our case, these sectoral laws, because
Yeah.
there is a provision of 238. So it does not say that IBC overrides each and everything. There are some
Yeah.
exceptions also. So we will pay attention to that in our coming case. Third question, whether RPs can be held personally liable beyond their statutory role.
Yeah, departments are trying to do that, but I don't think we have got a limited space to work. And within that
Yeah.
framework only we are working.
Hmm.
So it is always challengeable, and you get a relief from High Court, Supreme Court. That's it.
Right. So again, because we are always under the threat of being caught by any of the departments, or if we are not fulfilling the obligations in various laws, then we might fall prey to the penalties or fines, or we can be held personally liable at times. So again, on a safer side, it is mentioned that you need to have proper documentation of whatever you are doing. Just keep a track of whatever communication is happening with your clients, and keep a proper record of that. So it is better
And
to
I
have.
think
Yes.
IBBI must safeguard the RPs also. It's not one way, it should be two way.
Yeah, but they have not come up with that idea. So they are streamlining the process of CIRP, but they are not at all paying attention to our stake.
Yeah,
Yeah. So
that is
no,
true.
even if there are separate committees, they are asking again and again for a separate, like we have CS Institute, like we have CA
Yeah,
Institute, who takes care of your ethic of your, I mean,
problems.
working and all. So similarly, there has to be some forum which takes care of the insolvency professional also. But
Yeah,
everyone is there to, give us a
yeah,
beating. No one is there to
yeah.
help you around.
Support.
But whatsoever, this is the third question which we will be discussing in the coming case law. And the fourth question, whether preferential treatment of government claims is against the IBC framework. So this government claim, there is a, we already know that there is a particular waterfall mechanism, and there is a separate placing for this government claims. Then whether a preferential treatment will be allowed over and above that, I don't think that will be taken care.
Yeah.
And what is your view? I mean, if anyone has any other view,
No, it's
whether
all government specifically notifies, then only you can give a preferential treatment. Otherwise, everybody at par as per
like that rainbow
waterfall.
case, when that rainbow
Yeah,
case came, there was a lot of confusion what will happen then. So
yeah,
again, it was made very much clear that it is case specific. So with the
yeah,
facts and circumstances of each case, that
yeah.
treatment will be given. So okay, let us move further. This is the case which we will be discussing. Abil Menezes RP of Top Worth Urja and Metals Limited versus Ministry of Coal through its secretary and others. So again, this is a judgment which was pronounced on 23rd October 2024 only. So we are just discussing the recent judgments. So what is the fact of the case? Facts of the case. So the Topworth Urja and Metals Limited, which is the corporate debtor here, was granted the Marquis Mangli first coal block under a coal mine development and production agreement, which will be called CMDPA in short, dated 31st August 2015. So there was some agreement which happened with this corporate debtor and some the authority. So That is something which is mentioned here. Due to financial distress, Bank of Baroda filed a Section 7 IBC application, and NCLT Mumbai admitted CIRP on 12th August 2022. So whatever has started, whatever work they were doing in 2020, 2015, whatever agreement was there, coming further to 2022, then there was a situation of financial distress, and therefore the financial creditor, which is the Bank of Baroda, they filed a CIRP application on this particular corporate debtor. The Ministry of Coal, which is respondent number 1 in this case, issued a notice on 5th September 2023 withdrawing mine opening permissions due to the corporate debtor's failure to deposit the annual mine closure cost, which will be known as AMCC, in the escrow account. The resolution professional, that is the RP here, challenged this withdrawal before the NCLT Mumbai, arguing that AMCC is part of the corporate debtor's estate and must be treated under the IBC. The NCLT ruled in favor of the RP, but directed AMCC to be kept aside and held RP personally liable, personally responsible for coal disposal. Aggrieved by these directions, the RP appealed before NCLAT. So what is the issue arising? Whether the withdrawal letter, which is dated the 5th September 2023, could have been issued in view of the CIRP commencement on 12th August 2022 and consequential imposition of moratorium in terms of Section 14 of the Code. The next issue would be whether the mine closure cost up to the CIRP commencement date are operational debt or money held in trust. What is the status of that mine closure cost, AMCC, which we are talking about? So what is the nature of that particular cost, whether it will be treated as a operational debt or it will be treated as a money held in trust. So we are detailing these issues. First, whether AMCC is part of the corporate debtor's asset. The Ministry of Coal argued that AMCC is not an asset of the corporate debtor, but is held in trust for mine closure obligations. So they are saying that it is just like security deposit, which you do. The resolution professional countered that AMCC is operational debt payable under IBC waterfall provisions, and it is not a trust obligation. So what are the provisions which we should read regarding this particular case here? So it is Section 18F of the IBC, where it says that RP must take control of all the corporate debtors' asset. Section 14 is related to moratorium, as we all understand, and then Section 513, which defines CIRP cost, and it includes expenses essential to keep the business running. So whether this AMCC cost is essential to keep the business running, that is what we must understand. The next issue here could be whether AMCC can be kept outside the CIRP waterfall mechanism. Again, if we talk in detail about it, the NCLT's order separated AMCC from the CIRP, allowing it to be paid outside the IBC provisions. So they are saying that this amount will be paid separately and it should not be considered as a part of CIRP proceedings. The resolution professional argued that such treatment will give preferential status to the government, violating the IBC framework altogether. What are the provisions which we must focus upon in this particular scenario? Section 53 of the IBC, that is the waterfall mechanism. It says that government dues rank below the secured creditors. Then Section 238 of the IBC, it says that IBC overrides other laws, including the Coal Mines Special Provision Act 2015. Then there is a judgment in case of Sundaresh Bhatt versus CBIT. It says that government dues cannot override CIRP framework altogether. Okay, another issue which we can have some details upon is like whether the RP can be held personally responsible for the coal disposal. So the issue is the NCLT held the RP is personally responsible for mined coal disposal, which the RP argues was outside his role and against the IBC protection. So what are the provisions which again we must ponder upon here is Section 233 of the IBC, which protects the insolvency professionals from personal liability for actions taken in good faith. So this is a section which we must all, learn for ourselves, that if we are doing something in good faith, we cannot be professionally made liable for the things, for the allegations. Then Regulation 35A of IBBI, Insolvency Resolution Process for Corporate Persons, Regulations 2016. RP's duties are limited to CIRP management and not operational business risk. So again, I'm reading this out again. RP's duties are limited to CIRP management and they are not duty bound with respect to the operational business risk. So since we are being a professional, being a resolution professional, we are not aware of all the business or the operational risk. We cannot be held liable or we cannot be held personally responsible for all that. So we are only responsible for the CIRP management. Next issue here could be whether IBC overrides the CMSPA and MMDR Act. The Ministry of Coal argued that the CMSPA and MMDR Act provisions supersede IBC. This is what their view is. The RP argued that IBC has overriding effect, ensuring a uniform insolvency framework. This is the counter thing which he has made here. Contravention, the provisions which should be adhered to or which should be taken care in this particular regard are Section 238. It says that IBC overrides all other laws if inconsistency exists. So that is the main point. If there is any kind of inconsistency, in that case, this IBC will override. There is again a judgment of Innovative Industries Limited versus ICICI Bank, where it says that IBC takes precedence over sectoral laws at times. So finally, what are the observations? The adjudicating authority grossly erred in holding that the AMCC is not part of the estate of the corporate debtor and that the same needs to be kept aside. So NCLAT is clearly saying that AMCC, the cost, it should be included in the CIRP proceedings only. It cannot be treated separately. So the NCLT in their order, they have done a gross mistake while treating that separately. If the AMCC is allowed to be kept outside the CIRP of the corporate debtor, it would tantamount to giving the respondents a special status that is not recognized by law. Respondents cannot be paid in preference to other creditors, as that would defeat the purpose of CIRP and would prejudice other secured financial creditors who are members of the COC. This would cause serious prejudice to the discipline of the IBC and would set the salutary provisions of the IBC. Such ingenious method of recovering pre-CIRP dues will be setting a bad precedent and open room for government or statutory entities to devise contrivances to recover pre-CIRP dues in the garb of public trust doctrine. This will open floodgates for innovating new strategies to defeat the statutory scheme of IBC, which is complete code in itself for insolvency resolution process of the corporate debtor. So NCLAT is saying that we must be careful not to supplant and substitute the mechanism which has been laid down in the IBC framework with new mechanisms under judicial directions in the guise of the doctrine of public good faith, public good, and public interest. So finally, we are saying that AMCC is operational debt and not a trust obligation. The escrow agreement itself states that unused AMCC is refunded to the corporate debtor. This proves that AMCC is part of the corporate debtor's estate and not the independent trust. IBC overrides CMSPA and MMDR. The Ministry of Coal's argument that AMCC is outside IBC is legally unsustainable. Therefore, we can clearly say here that in this particular case, Section 238 will prevail. So IBC will prevail over these acts. Government dues cannot be treated preferentially. So this AMCC must be treated within the waterfall mechanism only, and that should not be treated separately. So allowing its full recovery would violate IBC's equal treatment of the creditors. So whatever treatment is given to the other creditors, similarly in the same fashion, this particular AMC cost should be also considered. So, and lastly, we can say that RP cannot be held personally liable. So NCLT's discretion to hold RP personally responsible is illegal. Section 233 of the IBC protects insolvency professional from personal liability when they are acting in good faith. So what is the final judgment? NCLAT set aside the NCLT's order to keep AMCC outside the purview of CIRP. In short, we can say that this appeal was finally allowed. So NCLAT ruled that AMCC must be treated as an operational debt under IBC itself. The direction holding the RP personally liable for coal disposal was finally quashed. The rest of NCLT's order, including the mine opening permission withdrawal, remained unchanged. So we are not bothered about that. So in short, what we can make out is RP cannot be held personally liable if he is doing act on good faith. Then again, with respect to those particular laws, IBC is overriding them on some particular sectoral things. IBC is overriding, having overriding effect, and particularly saying that AMCC will form part of the CIRP procedure itself. It is not that they should be paid separately. So if they are paid separately and others are paid from the leftover portion, that will create inequality altogether. So let us move further with the some more questions. I hope we can continue without a break. We'll try to.
I think we can have a 5-minute break.
Okay, okay, no problem, sir.
Thank you.
Okay. So we'll be back at 12:20 after 5 minutes.